Hello, everyone, and welcome back to Immigration Talk Show. Really happy that all you folks have joined us already. And you can let your friends know that there's going to be a very important webinar with very insightful information. So do join us, let them know to also join us. And welcome once again, friends. I'm Nipasa. I'm going to be your host for today's session. And I have this important disclaimer to read out before we start our session for today. And that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use at your own risk. So, once again, friends, thank you so much for joining us. We are streaming live right now on YouTube, and you check us out. Do subscribe to us. And by the way, you can also join us in this session by participating, and that you can do by commenting wherever you're watching. So, also, you can join us on call. All you have to do is dial this number 425 436 6335, and the access code is 988 888. So thank you once again, friends. And yes, today's discussion, as you can see the topic on the screen, it is going to be about the H-1B Lottery 2025 and the electronic registration, the process, and how to file successfully and avoid mistakes since it's the H-1B season and there's just a couple of days left. So, yes, stay tuned because there's going to be a lot of information in this session that you would not want to miss. And you can also ask your questions to our guest for today, none other than attorney Prashanthi Reddy. Please help me welcome her. Hi, Prashanthi. How are you doing today? It's always good to have you.
Great, Nipasa. Doing great. Good to see you as well.
Thank you so much. So, I'm excited for today's session because H-1B Lottery 2025 being a very important and timely topic right now. People have many questions and looking forward. Maybe you can give a sneak peek into what folks out there can expect from today's session.
Yeah, well, I guess we're talking about the do's and don'ts, what to look out for, how to file, basically how to file a registration, what are the key steps involved. Also, we will be discussing what the common mistakes are and how to avoid them when doing a registration. And we'll also talk about if there are any remedies. If you do make a mistake, if is are there any remedies to those mistakes and how to overcome them if possible. And if there are any changes with reference to USCIS from last year to this year or over the last few years that we should be aware of and we should take into consideration when, while doing the registration.
Absolutely. So, folks, what are you waiting for? Ask your questions if you have any, and Attorney Prashanthi Reddy will be very happy to answer. So, yes, Prashanthi, I mean, there's no more time. There's just 2 more days left. I'm sure it's been hectic for you and folks out there who are, getting into this lottery this time. So, my first question to you would be, about the of course, if you can provide sort of an overview, of the latest USCIS updates, um, and maybe tell us what are the changes this year that they really have to keep in mind.
Well, if we're talking in general about, are we talking in general about the USCIS updates or with reference to
Just
H-1Bs?
about
You
H1B,
want to,
H1B.
okay. So with reference to, and I'm not specifically talking about registrations, but there are a lot of changes to the H-1B process recently with the new H-1B regulations, and we covered this expansively in our, I think, previous shows as well. But one thing to keep in mind is that, especially if you are an IT company that sources out their employees to end clients, you should be aware that you would need purchase orders and contracts and client letters, vendor letters to show that there is availability of work. In the last couple of years, we've been seeing that USCIS has been approving these cases without those documents, but in the new H-1B regulations, they've made it clear that you have to show the availability of work, of specialty occupation work for any person that you file the H-1B for. So that's one big change. Of course, there's been changes with reference to how to define specialty occupation. There's in the sense that they've included H-1B type where you could own part of the company and still file a H-1B from that company, and the do's and don'ts. They've said what you can do, cannot do. They're given a time period for that, which is lesser than the regular H-1B type. So those are some of the changes with reference to the H-1B regulation. But another update I wanted to give is breaking news as of yesterday. USCIS has posted a memo for their is basically stating that the way it works with H-1B employees, uh, to the extent that it affects H-1B people, that NTAs or notice to appear should be given to H-1B or other non-immigrant uh, employees or people as well. If their H-1B gets denied or if their non-immigrant petition gets denied and they are not presently in status. What is an NTA? NTA is a notice to appear for removal proceedings. So they are basically saying that if you are not in status, your I-94 has expired, you filed an extension while your I-94 was still in status, but it took a while and your I-94 expired and then your H1 got denied for some reason and you are no longer in status, you will be issued an NTA. They did this even during the past Trump period. So we have to wait and see if they intend to enforce it strictly. They didn't really do that in the last Trump administration, though they did give a similar memo out saying that NTS should be issued to anyone who was on H1 and is not in status, but they didn't really issue those NTOs to a great extent. So we have to wait and see now if they do it more seriously. But they have certainly indicated that that should be done. Just to let you know, in the past, even if you're out of status on a H-1B, ICE doesn't usually come knocking on your door. You don't get notices. Of course, you would want to leave because you don't want to get accumulate unlawful presence, and also because you cannot work if you don't have status. So most people would leave anyway. But these NTAs are really a pain because once an NTA is issued, you cannot leave even if you want to. And it could take years pretty much for that, if you go to court for that NTA to be resolved, for the removal proceeding case to get resolved. It's difficult to go and get and self-deport, because if you self-deport, then you're considered to be deported or removed, which means that you cannot come back into the country. Um, and you cannot file for a change of status or a nunc pro tunc, like a change of status on humanitarian grounds like we used to before once the NTA is issued. So there are a lot of implications with this issuance of an NTA. So I would advise employers to be careful. If your employees I-94 is expiring, make sure you file well in advance, 6 months ahead if you can, file in premium processing, and try to get a response from USCIS before the expiry of the I-94. Same thing with a transfer. If you're filing a transfer, I would say don't join the new employer once the transfer is filed, which I know you can do based on AC-21. You don't have to wait for the approval. But if you don't wait for the approval, you join the new employer and USCIS denies the case, then you're stuck. Then an NTA might be issued because you're now out of status. Because the previous employer might have withdrawn your H1, right? So we don't know exactly in what circumstances they will issue these NTAs, but it's better to be safe rather than sorry, and better to follow a path of caution. So that's, I think, my updates for today.
Thank you so much. Very important updates, Prashanthi, and thank you for highlighting them, I would say. And without further ado, I do have a few questions. So, if you can tell us, especially for employers and applicants out there who are watching us right now, what key steps should they follow, to ensure a successful H-1B electronic registration for this year's lottery?
Well, first of all, I think you should create your USCIS online account. You have to create what is called an organizational account. So make sure you create the right account. Don't create an applicant account or a petitioner account. Follow instructions to create it. There are plenty of videos out there on how to create it. So once you have created your account, whether you're doing it through your attorney or you're doing it on your own, gather all the documents that will be required and all the information that's required. I mean, you should collect information such as the full name, date of birth, contact details of your employee, passport number, country of citizenship of your employee, of the person applicant that is filing for registration, um, and so on and so forth. Also, to complete the electronic registration process, as I said, you need to your USCIS account and complete the registration online. You can submit multiple registrations for multiple employees at one time, but each registration must be unique, which means that for the same beneficiary, you cannot submit more than one registration. The registration form basically asks for basic information about the employer and the benefit. Make sure you have your federal ID number, your address, the signatory, the name of the person who will be signing the document, that basic information ready before you start filling out your registration. But you can also save your registration and submit it later if you find that you don't have some of the information that they're asking for. Also important that you pay the correct registration fee amount. There's a non-refundable registration fee of $210 from $10 from last time. 215, I believe. Sorry, not 210. So they must pay this fee online when submitting the electronic registration. Make sure you submit that registration during the designated period. So March 7th is when the registration is opening up, and March 24th is when the registration is closing. So make sure you file within that window. If you file a late submission, they will not accept it. If you file a registration on the last day, you're risking it, because if there's something wrong, then you will not be able to resubmit. Of course, after you file, you monitor the registration results. After USCIS, after you file and the date after March 24th, USCIS will conduct a lottery, and it always exceeds the annual cap, so there'll definitely be a lottery, and employees will be notified of their registration, whether their registration was selected or not, by end of March or early April, before April 1st. And of course, if you get selected, then be prepared to submit your registration within 90 days of acceptance. Make sure you don't miss out on that 90-day acceptance period, because if you file later, again, they will not accept it. For the applicants, make sure that you meet all the basic eligible criteria for the H1. I mean, you don't need to for the registration, but there's no point in filing a registration if it doesn't finally get approved, right? So make sure you have a bachelor's degree in a specific field which is required by that particular occupation. Make sure your employer has actually registered for you, and they have done it correctly. Ask for receipt of that registration. Double check the information that you're giving them, such as the date of birth, passport details, etc., so that there are no issues with your registration. And also keep your supporting documents ready, like your degree copies, experience letters, etc., so that you'll be ready to file on a timely basis. And as I said, just tips for employers: double check all the information that you're providing, stay updated with all the every day there's some new news coming out, so stay updated on what USCIS is saying and what changes they've made. And of course, always have an attorney. It always makes sense to use an attorney, because they will be aware of what the changes are, and they will ensure that your registration process takes place smoothly.
Absolutely. Thank you so much, Prashanthi, for highlighting what we should keep in mind for this year's H-1B lottery, and also, to so as to avoid all these common mistakes that could lead to rejections or being not being able to be valid applicant for this year's lottery. So, thank you, Prashanthi, once again. Now, moving on, if you can also tell us about how USCIS has enforced changes, regarding multiple registrations and fraud detection, and what precautions should companies take?
Well, so just to give you some context about multiple registrations, the year before last, before USCIS made the lottery system beneficiary centric, we saw that there were about 780,000 registrations as opposed to 300,000 the previous year. So it more than doubled, and out of that 780,000, half of them were duplicates. So USCIS realized that this system is not working; it's compromised. So and I don't know why they didn't just do that before, but they came to their senses and they implemented a beneficiary-centric registration process whereby the person is put into the lottery based on their passport ID. So if they file several registrations, they will only get one entry into the lottery. So with uh, having done that, they are now less concerned, I think, USCIS about multiple registrations. In the new H-1B regulations, they had the chance of putting in language with reference to, what happens if you do multiple registrations, what are the penalties that employers face. I mean, they already have issued a memo with reference to that, but it was not part of the regulation. But they did not actually put it part of the regulation, and in fact, they said that there was no need to, because they think registration is no longer an issue because people will not file multiple registration because there's no incentive to file multiple registrations anymore, right? But if you do file multiple registrations, you will still get an RFE. Your case will still get denied, and there might be still some punitive action taken upon you. And I must let you know that USCIS has become more advanced in finding out about multiple registrations, especially, I mean, multiple registrations anyone can find out because, that we're talking about one company filing duplicate registrations and the registration doesn't even get accepted. But what I'm talking about is collusion. And that's what I was talking about when I said that, they didn't include that as part of the avoiding, forbidding collusion and the penal action that can be taken if you do collude. What is collusion? When two or three companies get together and file for the same beneficiary, so that to increase the chances of that beneficiary getting picked in the lottery. So I was talking about collusion, multiple registrations. Of course, it's pretty straightforward. You do a multiple registration, it will not even get picked in the registration. But if you do collusion, USCIS has become more advanced. They have advanced algorithms and data analysis to detect multiple registrations for the same employer through multiple organizations that are somehow. For example, they will check the IP address and see that the registrations have been done. The names of the companies are different, the address is different, but maybe the registrations have been done from the same IP address, and that's how they track registrations done with the intent to collude. Also, they have implemented more rigorous data cross-checking to identify patterns of multiple submissions, whether intentionally or done through an error. They've identified ways of checking collusion. So there's multiple registrations, there's collusion, and there is an issue with both. They've also, USCIS has come up with increased fraud detection mechanisms. Um, to in general also, I mean, to multiple registrations, but with reference to misrepresenting job titles, fake job offers. A multiple registration through collusion is really a fake job offer because every company doesn't have a job for them. It's not a unique job. It's the same job which all the companies are offering to them. So it's a fake job offer. And general misuse of the H-1B system. So
Right.
yeah, USCIS will likely conduct site visits. They will revoke registrations. They will revoke H-1B petitions. Also hold the employers accountable for third party. You can't even say that, oh, my attorney did it. Oh, but I outsourced this to a paralegal. The paralegal did it. It's not my fault. The employer is still accountable, and USCIS holds the employer accounting. So USCIS will send a notice of intent to revoke if they see collusion. They will they will basically not accept registrations that multiple registrations, so you won't even get into the lottery or be counted towards the lottery.
Mhm.
As a precautionary step in order to avoid multiple registrations, ensure that, obviously ensure that only one registration is submitted per beneficiary. Do better vetting within your company. If several people are doing your registrations from different branches, say, there is an USCIS organizational to download all the information into a CVV file, and so that then you can detect the duplicates. So make sure you do that before you actually submit the registrations into one file, and then check for
Mhm.
it gets that way. Of course, USCIS will automatically check for duplicates if you've filed one batch and you've submitted the registration, then you try to do a registration for that person again. Then it will detect it automatically, but they don't detect duplicates based on two drafts which have not been submitted. So make sure there's proper communication between, all the parties involved that are doing the registrations. If your attorney is doing it, don't again, do the same registration. And monitor your third party vendors, whoever, if there's someone else is doing the registration for you. Again, stay updated with reference to, all USCIS policies with reference to multiple registrations.
I really like how you said that this should have been done earlier, but yes, it's happening now. And Prashanthi, 20 years of experience in this immigration field. Would you like to maybe share any case study that could be related to H-1B and fraud, or anything that comes to your mind, that you dealt with?
With reference to multiple registrations, since and collusion, since that's what we're talking about, there have been many instances of people doing that because they didn't realize, first of all, that USCIS will be able to figure it out. And they didn't
Mhm.
realize the seriousness of it because they were like, oh, that person is doing it. Why can't I do it? Everybody was doing it pretty much. And they thought that because everybody's doing it, nobody will get caught. But USCIS, though they cannot catch everybody, will catch as many people as they can. And you might be one of them, right? So you can't be certain that you won't. So that's why, and I've seen lots of instances where that's happened and they've revoked
Mhm.
cases. I mean, even last year when there was no need to do multiple registrations, people have done it simply because, their employees wanted them to do it. Um, I'm like, why would you not tell your employees the downside of doing it? There's no upside of doing it, but there is a downside, and which is the fact that even if the registration is picked, then even if you get it approved, it can get revoked, or there could be an RFE, and then they've lost their opportunity to, get a H1, and you might have lost your opportunity to file H1s in the future. So yeah, there are many
Mhm.
examples in which USCIS has found fraud with reference to multiple registrations. And they have come and visited. And there is also instances where they've actually penalized them in the sense that uh, they're considered to be a crime.
Banned.
and placed criminal charges against these companies. So
Okay.
something you want to avoid.
Absolutely. Thank you so much, Prashanthi, for highlighting them. And yes, with that said, I would like to say hello to folks out there who have joined us: Supriya, Madhuri, Mohandas, RK. Thank you so much for joining us with your questions. And I think we should address some of them. So let's take up RK's one. What will be the impact of USCIS who's looking to issue NTA for more cases than the requested immigration benefits are denied?
What will the impact with USCIS? Or if USCIS is looking to issue NTA for more cases that yeah, so there are a lot of issues here. I think number one, don't, if your case has gotten denied, then leave the country immediately. Don't hang around hoping that something will happen. If you do hang around, then file an appeal so that you're protected against removal proceedings, because you have an appeal in place, you're allowed to stay in the country with that appeal pending. So definitely, even if you think that there are less chances of your case getting approved on appeal, you should just file it so that you can preserve your chances of staying here and giving yourself some breathing room.
Mhm.
Um, also, again, I said with reference to transfers, be careful if you're going to start working for your new employer even before um, the H1 gets approved, then be aware that if it gets denied, then you know, and if the previous H1 was revoked, because the employers usually withdraw their if you stop working for them. So I would say file your transfer in premium processing and then move to the new company after it's approved, so that you can avoid again receiving an NTA. Don't stay beyond the 60 days grace. You have 60 days grace. I don't think they'll issue an NTA within the 60 days grace, but you have to remember 60 days grace is also discretionary. So they may decide not to give it to you, though I haven't seen that happen, but it could. But you have to be aware that's discretionary, and a lot of people don't know that. So if it gets be subject to an NTA. So overall, you have to be more cautious about uh, falling out of status. Apply for your extension as soon as possible. Don't wait for the last few months to apply. You can apply a maximum of 6 months in advance, so do that. And do it in premium processing, so you're not in a situation where your I-94 has expired and your H1 gets denied. Another last tip is avoid filing anything with USCIS if you can help it. More exposure to USCIS means more chances of getting a denial, more chances of getting an NTA. So avoid filing anything with USCIS if you can help doing that.
Okay. That's interesting, the last point. But thank you so much, Prashanthi, for bringing that up and taking this question for RK. And RK, I hope you're happy with Prashanthi's answer, response to your question. If you have any further questions, keep commenting. Now let's take up this next one from Supriya. My job title is data analyst, and USCIS issued an RFE questioning if it qualifies as a specialty occupation. Under Trump's policies, are non traditional STEM jobs more likely to get denied?
Well, I don't think a data analyst is a non-traditional STEM job. I think it's very much it is a STEM job. But data analyst positions are always. Um, I'm not surprised that you got an RFE. It's pretty common to get an RFE on a data analyst position. If you say data scientist, you might not get an RFE, but if you say data analyst, you might. So it's important to, before filing a H1, to explore that job title, explore the job duties, and see. And a good attorney will do that and see what is the likelihood of getting an RFE, and if possible, tweak it if you can. Um, though it's the job description that's important, the job title also will, sometimes USCIS just looks at the job title and they'll issue an RFE based on that. So I would say if there are internal job titles within your organization, um, uh, that may more accurately represent your job description. Use those. Um,
Mhm.
but I wouldn't say that it's impossible to get a approval on a data analyst RFE. Definitely, there is very good chances of getting approvals. You just have to do it properly, respond
Mhm.
properly to everything that they're asking for, prove that it's a specialty occupation. Um, in general, non-STEM jobs might be more likely to get an RFE, especially not just under Trump's administration, but maybe more so under his administration, if the job is kind of borderline with reference to specialty occupation or not. A lot of non-STEM uh, jobs, especially if they require like a bachelor's degree in business administration or a bachelor's degree in liberal arts or a bachelor's administration in science, and they don't specify what field of science. So if the industry just requires a broad bachelor's degree, and that could be the case in a lot of non-STEM fields, that's the reason why you might get an RFE. But if it is, even if it's a non-STEM field, if there's a requirement for a specific degree, like say economist, a bachelor's degree in economics, it's a non-STEM field, but it's still very much a specialty occupation. Um, so, it depends from job to job, but it's more likely in a non-STEM field that you'll face difficulty rather than like an IT field where, the requirement is clearly a bachelor's in computer science. Or for that matter, another example in non-STEM field would be an attorney, right? I mean, an attorney definitely requires a JD, a bachelor's degree in law to practice. So even though it's a non-STEM field, there's no question that it's a specialty occupation. So it really depends from job to job.
Right. Very well explained. Thank you so much, Prashanti. And so, Priya, thank you for asking your question. Keep commenting. We really appreciate it. So, this next question is from Mohan Das asking, I am a Germany blue card holder. What are my options to move to US? And what would be a rough estimate of amount I would be spending for applying H-1B?
Um, your options, you can move as a student. If you have an immediate relative, you can ask them to file a green card for you. If you have a job in the US, you can apply for a H1. Your employer can apply for H1. Your estimate amount should be zero because your employer should be spending uh, for, you should be filing, I mean, paying for the USCIS fee and the attorney fee, etc.
Okay, thank you so much, Mohan Das, for your question, and thank you, Prashanti.
I mean, there are
Now,
other
well,
options as well. You could,
yeah.
I mean, a multinational executive L1 could be filed if you are working for a multinational company in the US, in Germany for the last 1 year as an
Mhm.
executive, and or a manager, and you're looking to move here to work for their branch office or their subsidiary or their related company. You can also file an E2, which is a treaty investor. I think Germany is also part of the is considered an E2 country, but I'll have to look that up. So yeah, these are some of the things that you can do.
Okay. Thank you, Mohan Das, for your comments, and thank you, Prashanti, for taking that up. So, Madhuri, now this next one is from Madhuri in YouTube asking, I'm applying for the H-1B lottery this year, but my employer is worried about my new wage based selection rules. Will lower wage applicants have a realistic chance, or will most H-1Bs go to those with the highest salaries?
So nothing has changed with reference to prevailing wages. The Trump administration has been talking about changing it, but they haven't changed it yet. So it does not affect the present um, gap season. But having said that, wages do increase every year, and so it has increased by 10-12%. Um, it increases every year. So from that point of view, yes, it becomes more and more difficult uh, if you're getting paid the lower than the prevailing wage. You could use level one if you are a fresh graduate, but if you're going below level one, um, And if you don't want to use the prevailing wage from the Department of Labor website, then you can do your own wage survey and see what comes up. It's expensive to do your own wage survey, but it can be done, and maybe you'll get a better wage there.
Right. Okay, thank you so much, Prashanthi, and thank you, Madhuri, for your questions. So, Prashanthi, that uh, there are a lot of changes this year as well, and I really hope that everybody, they go through this process well. They're able to file their, fill in their forms and get into the lottery. But yes, if selected in the lottery, what are the next steps that applicants should follow to avoid delays or denials during the petition filing?
Um, well, first of all, you have to review your lottery notification. And the attorney will receive a notification from USCIS that your application has been selected. So verify that you've received that. You have to log into your USCIS account to check whether you've been selected or not. Once you've received the lottery, just pay attention to it. See where they say you have to send the petition to, and send it to that address. Um, so pay close attention to the lottery notice. Also pay attention to the last date when you should file. That's also in the lottery notice. And of course, you have to file an I-129 petition. This petition must include detailed documents about the applicant, the job, the employer. You need to file, before you file the I-129 application, you have to file the labor condition application, the LCA. And you have to gather all your documents like the applicant's educational credentials, their degree copies, and get an evaluation done if it's a foreign degree. Experience letters, if that's required from the beneficiary. Of course, they have to have passports, and their passports have to be valid, even for a registration. There was recently a person who came to me for a registration. His passport expired in 2021, and he didn't notice it. And he can't do the registration now. He has to try and get his passport updated and get it renewed, but he may not have enough time. From the company point of view, get all your offer letter in place, your company documents, tax filings, proof that you have an office space, your lease, and proof that you have work for the person that you're going to hire. If that person is going to be working for a client, then that would be, purchase orders, MSAs, contracts, client letter, vendor letters. Show that you have all that. Make sure the information in that document matches with the information in your LCA, matches with the information in your I-129 petition. If there's discrepancies, you're better off not including the documents than including documents with discrepancies. And finally, make sure you file within the 90 days. And with reference to documents and information that have to be provided, job description also is important. You have to include a clear, detailed job description, job duties. There has to be a letter which also mentions the employer's business, why the job is a specialty occupation, why a bachelor's degree is required, why the employer requires you, and how they have enough work for you to be hired in that particular job. All this is, you have to submit a letter which has all this information in it. The job description has to show that it's complex, and a bachelor's degree is required to perform those jobs. So be careful with the job description. It's very important. Sometimes even if your job title is, say, a software developer, but if you put in duties of a programmer, testing, programming, then you're going to get an RFE saying that, yeah, your job title says that, but your duties actually don't show that you're working as a developer. You also have to show that your employer has the financial stability to be able to pay your salary. Um, that again can be shown by the volume of business that they have. And the filing fee, make sure that you submit the correct filing fee. There, the filing fee is very complex. There's a base filing fee, there's the ACWIA filing fee, there's a fraud prevention and detection fee, um, and there's also now the new asylum fee, and the fee is different depending on how many employees you have. Over 25, there's a fee. Under 25, there's a different fee. So USCIS has a very useful tool for this. So use that USCIS tool, where a fee calculator tool where you can put in all the information and it'll calculate the fee for you. That's a very useful tool to have. Last but not the least, when if you get an RFE, of course, monitor your case. Uh, if there is action required, such as if you get an RFE, make sure you wait for that RFE. If you don't get the RFE in the mail, call them to find out why you didn't get it. Because sometimes if you don't pay attention to what status is on the website, you might have an RFE because there's some mess up with the post office and they don't mail it to you. That happens quite often, more often than you think. And then the H1 might because you don't respond to the RFE. So keep an eye out for what your status online. And if you see that there is an RFE, then read the RFE carefully. Provide all the information that they're asking for. Don't respond in an incomplete manner to the RFE. And respond promptly on time because there is a deadline to respond. And send it to the right office. The RFE will tell you which office to send it to. I think, that is, a few of the things that you should do once you get picked to have a successful approval.
Thank you so much, Prashanthi. And I'm sure that folks out there are very excited, nervous, anxious at the same time. But here's wishing each one of you who are preparing for this H1B season all the best. It's going to be all right. And stay with us because we are going to be back right after a short break and we'll take up more questions with none other than immigration attorney Prashanthi Reddy on Immigration Talk Show. Hello and welcome back, everyone, to Immigration Talk Show. And today we are discussing about H-1B Lottery 2025 electronic registration and how to file successfully and avoid mistakes with none other than our guest for today, attorney Prashanthi Reddy. And it's been very interesting so far. Thank you so much, Prashanthi, for taking up so many of our questions very patiently. And there are more to go, so I hope you're ready. And
I am.
yeah, so
Bring them on.
yes. Let's go for it then. So, Control, if you can also, put up our questions from our YouTube, since we have so many people asking many questions, it'll be very nice. So, let's take up this first one. This is from Mungelkar. Hi, my employer is willing to sponsor H-1B but doesn't want to pay for fee and attorney, is there any way we can share payment or is there any legal way we can do it?
For the registration, they definitely have to pay the registration fee uh, for the attorney as well as for the registration. I think the attorney fee, if there is any. Um, for the USCIS fee, definitely, I mean, they should pay the USCIS fee, but there's some fee that is completely mandatory that USCIS, that the attorney pay, sorry, the employer pays. Um,
Mhm.
But in general, I think it is prudent for the employer to pay the USCIS fee, but the premium processing fee is something that the beneficiary can pay.
Okay, thank you so much for taking that up. And let's go on to our next one. Control, please. This is from Sandeep asking, hello, I have H4 and didn't travel to USA yet. I was picked in 2025 H1 cap. Do I need to be in the USA for status change from H4 to H1B? What will be my options?
Yeah, you could come on a H4 and then file a change of status from H4 to H1 based on the fact that you're cap exempt. As of now, they would consider you cap exempt. I don't know if they would change that, how they see cap exempt cases or who is cap exempt in the future. But as of now, I think you would be cap exempt. So if you don't want to go for a visa, H1 visa, then that's what you would do.
Okay. Thank you, Prashanthi, for taking that up. And now let's go on to our next one. This is from Raja. If the H-1B lottery is based on passport number, what will happen of two employers applying H-1B for same person?
That's fine if two employers apply for the same person, as long as there's no collusion between the employers and the job offered is independent. Each have has their own job. Like you, for one company, they're hiring you to work with AT&T, and the other company is hiring you to work for UBS.
Mhm. Okay. Thank you, Prashanthi. Thank you for taking that up. And this next one is SSS is asking the lottery system to be abolished and preference to be given only to the merit. In this lottery system, unworthy people are um, trying through fake consultancies and stealing the diets of genuine candidates and getting 2 to 1G in interviews. And finally, revocation. USCIS should put lifetime ban for them on them. What do you have to say on that?
Um Harsh, but yes, if there's fraud, they have to face consequences. So that, as he said, people who are genuine and I think, I mean, so I must say that that's not happening as much now with the lottery fee. I'm hoping with the lottery fee having increased, the registration fee having increased, and with um, the multiple registrations not happening as much. I think the fraud has gone down significantly, but there still is fraud, and I agree that they should face consequences if they file frivolous registrations for people and take money from people, just file registrations, not even have a job for them. That's what I think he's referring to, and I agree.
Yes, absolutely. Thank you so much, Prashanti. And last but not the least, this one is from Rajkumar asking, my wife on H4 I-94 is till passport expiry date. What to do after getting new passport? Can she apply to extend the I-94 same as mine, that is H1? If so, where? Kindly please advise.
If she's in the USCIS, if she's in the US, she would file an extension with the USCIS. If she's outside the country, she just has to, if she has a visa already, even if it's on her old passport and if it has not expired, then she can just come into the country and she'll get a new I-94. Or if she's outside the country and her visa is expired, then she'll have to go for a new visa. And then she'll get a new I-94 upon arrival.
Right. Right. Thank you so much, Prashanthi, for taking that up. And I think with that, we've covered our YouTube questions from our viewers. Thank you, Prashanthi. And we got more questions, though. So let's go ahead and not keep them waiting. So let's take up Mohan Das, who's back again, asking, would it make any difference if I apply after taking German citizenship?
I think I covered that, even though you said because I know you said you are not a German citizen, but I did cover it. If you are a German citizen, then you might be able to apply for an E2, which is a treaty investor or treaty trader visa. That is, if you're investing in certain amount of business money into the US, or your
Mhm.
employer is investing a certain amount of money into the US in a business, and they want to send you to manage that business. That's called an E2. Other than that, there's no other special privileges for German citizens.
Okay. Thank you. Thank you, Mohan Das, for participating very actively. Now I got Vikas. Vikas is asking, the registrant or the organization for whom the registration is submitted has not worked with or agreed to work with another registrant, petitioner, agent, or other individual or entity to submit a registration to unfairly increase chances of selection for the beneficiary or beneficiaries in this submission. My understanding is of this is if I file two H-1B applications, both will be rejected. Is that correct?
Because are you the employee or the employer? Um, and just to get you to understand what this means, is that if there are two organizations and they both file a registration for you, and if they're not related to each other, and if they have not colluded to decide to file for you in order so that you can increase your chances, um, there is no collusion and there is no problem. You can file more than one um, registration. You can file a registration through both the companies. And also, the job has to be different, as I said before. If the job
Mhm.
is separate in each instance, then you can file through both.
Okay. Okay. There you go, Vikas. You have your answer. Thank you, Prashanthi, for taking that up. And Prashanthi, if you could also highlight some of the red flags, that USCIS looks for in H-1B registrations, and how can employers really ensure compliance with regulations?
Red flags is basically, I think we talked about collusion.
Yes.
We talked about, I think we talked about this, Nipasa. We talked about
Okay.
collusion, avoiding duplicate registrations. We talked about, uh, and I can tell you that typographical errors should not be made. So make sure you enter the right the passport ID number, the correct spelling of the beneficiary's name, right address of the employer, your correct federal ID number. Because if you do a registration and you have wrong information in there, if it gets picked and you have to file the H1, you might have some issues with, you'll have to explain the discrepancies at that point of time. So make sure you enter all the information correctly. Do the
Mhm.
registration. Don't do it in the last minute. That's a red flag. Because if it doesn't get picked, or if you notice later on that there's a duplicate, that you did it twice for the same person, you will not be able to then delete one of the registrations because the system will close you out. So do it ahead of time. Doing it at the last minute is always a problem.
Right. Thank you, Prashanthi. And Vikas is back saying that I am an employee, and thanks for your answer.
Okay.
Anyway, so Prashanthi, now if you could also, tell us if a small IT consulting firm submits H-1B registrations for 20 employees, but 15 get rejected due to alleged duplicate filings. What legal options do they have, and how can they prevent this issue in the future?
So when we say duplicate filings, we're obviously talking about collusion.
Yes.
And um, I think what we're talking about here is that, registration was done, case was filed, and then in an RFE, USCIS is alleging that there is duplication due to collusion.
Mhm.
In that case, when we say alleged, that means maybe there isn't duplication. So if there is really no duplication and USCIS is alleging that there is duplication, then you have to prove to them that you have no relationship whatsoever with that other company. That, and we've heard these stories that they are agents that employers get their resumes from, and the same agent is giving the same 10 resumes to various employers. So various employers might be interviewing these people, and that might be one reason why there's duplicate registrations. The same employer, the different employers have the same people in their list. So that could be one explanation. And you can always, it could be a coincidence, but of course it's 10 or more are the same, then it may not be a coincidence. But if it's one or two that are the same, it's unless, if you have really done no collusion, there is always ways of showing it, submit an affidavit, um, refuse to acknowledge that, you had any knowledge or that you colluded with this other employer. You can also show
Mhm.
that the job offer is completely different, that your job offer for this person, you've done it because, you have a job through blah, blah. You can show proof that you have a job. You can show the contract, you can show the work order, etc. So, despite that, if they deny it, then you can file an appeal or you can file a motion to reopen or reconsider. Um, and you can seek judicial review after that. You could even file a case in court. And of
Mhm.
course, before you do any of these things, contact your immigration attorney to find out what is the best course of action. Um, but if it's just based on multiple registrations, they say that there's a duplicate registration, but there isn't. There wasn't one. And then they deny your registration. I don't think there's much you can do other than refile that registration. That's why I said that make sure you file much before the deadline, because if there is even some fault on the part of USCIS and they deny your registration, you can refile that registration. Um,
Mhm.
and I think that might be another way of doing it. Um, because there's not much you can do with reference to an appeal for for the registration part. But
Right.
prevention is always the best cure, right? So avoid obviously potential duplicates. Have like a robust internal filing system whereby you can easily detect duplicates. Use a tracking system. Educate your employees that they shouldn't file, uh, that what can and cannot be done. And of course it always helps to have a experienced immigration attorney help you.
Right. Right. Thank you so much, Prashanthi, for taking this question up as well, and for helping us, with some of the points and tips to keep in mind today, since this H-1B season it is, and there's so much going on, and people are really preparing themselves for this season. So, thank you so much. And maybe before we leave, if you can just give out a maybe like an end note or anything that you want to say to the audience out there and for those who are preparing also.
I think it's important to keep in mind that there is a short window for filing registrations, and
Mhm.
also that there's a 30% chance of your registration getting picked. So don't lose that opportunity, especially if you're on an F1. make sure you file your registration every opportunity that you get, because even if you have 3 years on your STEM of what, 3 years on your OPT, including STEM OPT, that may not be enough time. So
Mhm.
if your employer is not willing to do the registration, find a new employer. Um, ensure that the employer files your registration within the well before the deadline.
Mhm.
Ensure that, whether it be the employer or employee, that you do it correctly, because again, there's only one chance that you get every year, and even that,
Mhm.
is a lottery system. So it's becomes even more important to do your registration properly.
Right. Right. Thank you so much. Friends, I hope that you really resonated with all whatever Prashanti had to say today, answering so many of our questions. And I hope that you resonated with each of her answers as well. So do not forget to like, share, and subscribe our content, especially this one. And do not also forget to hit the bell icon so that whenever we have discussions and webinars as informative as this one, you are notified, and maybe you could also join in to ask your questions. So also do not forget to check out attorney Prashanthi Reddy, who has been such a sport, answering so many of our questions. You can also have a one-on-one consultation with her, get in touch with her for your questions, and let her know that you are connected to her through Immigration Talk Show. She'll be happy to know. And yes, email her, prashanthi at reddyesq.com. That'll be the best way. But otherwise, if it is an emergency or very urgent, maybe you can even give her a call. And her number is 212-354-1010. And definitely go visit www.reddyesq.com to get to know more about Attorney Prashanthi Reddy and the law offices of Prashanthi Reddy. So thank you so much once again, Prashanthi, for today's session. And I'm already looking forward for our next one when you can join us.
Thank you. It's a pleasure as always being here.
Thank you, Prashanthi. Have a great day ahead. And folks out there, thank you once again for joining us. And with that said, also check us out. We are Immigration Talk Show. Our handle is Immigration Talk Show on YouTube. Do not forget to subscribe to us. And also check us out on LinkedIn, Facebook, X, Instagram, and connect with us, all right? Also, you can email me. My email address is nipa@staffingly.com. You can send in your questions, queries, and we will be able to put it up accordingly to the attorney, or give you a response accordingly. Thank you. And also you can WhatsApp me or call me on my number. My phone number is 408-335-6444. Thank you so much once again. Have a great day ahead, and stay tuned on Immigration Talk Show, because there's so much you do not want to miss.